Good afternoon and welcome to the Advanced Practitioner Series. My name is Patrick Shepard. I'm very pleased to be joined today by Rachel Dowell, Christopher Swartz, and Sikora Panza, all from OGE's Ethics Law and Policy branch. In recent months, OGE has issued a number of targeted legal advisories dealing with some narrow questions that we receive often here at OGE, and today we'll be providing a survey of that guidance. Before we get into the substance of today's presentation, I have a few administrative announcements. First, I'd like to thank everyone who registers for these courses. By registering, you allow yourself to be counted and OGE to take credit for your attendance at these presentations. Also, you allow us the important opportunity to receive your feedback on the presentations. And to that end, after today's presentation, you should receive a course evaluation. Please complete that evaluation and provide your feedback. It's extremely valuable in helping us to improve these broadcasts and plan for the future. Thank you for those who frequently do that. Also, we'll be back in July with our regularly scheduled series. On July 9th, we will be back with the Fundamental series, and on the 16th, the Advanced Practitioner series. Look for those training announcements in the next couple of weeks. We'll also be hosting a post-employment massive open online course sometime in the next month, so please look for that as well. Well, welcome, Rachel, Chris, and Kim.
Thanks for having us.
So, I'm really glad that you guys could join us, and we're looking forward to today's presentation. I think we'd like to start today with Rachel, who will be discussing Legal Advisory 1506, which provides guidance on the application of the Employee Benefit Plan exemption. So it's all yours, Rachel.
All right, thanks, Patrick. So today I'm going to discuss OGE's recently issued legal advisory on the Employee Benefit Plan exemption. Specifically, this legal advisory focuses on the application of the Employee Benefit Plan exemption in two different scenarios. First, to pooled investment funds, and second, to foreign employee benefit plans. But before we get into these specific applications, I'm going to provide just a little background on the exemption so that we can get our bearings. Generally, an employee benefit plan is any plan, fund, or program established or maintained by an employer to provide retirement income. Now, if you actually look at the definition in our regulation, you'll see that this provision also applies to employee benefit plans that provide various other types of benefits, like medical or unemployment. But for all practical purposes, most of the plans that you'll come across are some form of employee savings or retirement plan that provides deferred income, typically after the employee is retired. Now, employees ordinarily have a financial interest in the holdings of an employee benefit plan that's set up as a defined contribution plan, since those holdings are the assets that are going to generate their retirement or other income. So for employees who continue to participate in these employee benefit plans, they're going to be prohibited by 18 U.S.C. 208 from participating in particular matters that affect the assets held in the employee benefit plan, unless, of course, there's an applicable exemption or an individual waiver. So much of the time, you can use the mutual fund exemption for many of the funds you invest in through an employee benefit plan. But that's not always the case, because some of the assets you might find in an employee benefit plan are not going to meet our definition of mutual fund. So, because of that, OGE promulgated an exemption that would permit an employee to act in particular matters affecting the holdings of an employee benefit plan, as long as that plan meets certain criteria. Now, Legal Advisory 1506, it doesn't actually touch on all of the criteria for this exemption. Rather, the legal advisory focuses on discrete elements of the exemption that are relevant to our two scenarios, with the caveat that, of course, you have to also meet the other elements. For example, that it be administered by an independent trustee, and that the plan can't be a profit sharing or a stock bonus plan. So with that caveat that you need to meet those criteria, the legal advisory then goes on to focus on the application of the exemption in our two specific scenarios. For the first part of the legal advisory, we're focusing on whether the employee benefit plan exemption is applicable to diversified pooled investment funds. And off the bat, the answer is generally yes, as long as it meets all the criteria of the exemption. Now, the reason we're addressing this issue is to clarify what's meant by the criterion that says you can't select the plan's investments or designate specific plan investments, except for selecting general investment strategies of sorts. So it's clear from that statement that you can select generically an investment strategy, such as indicating that you want to invest in bonds. But it's come to our attention that it's not exactly clear whether you can use this exemption if you go into your plan and select specific funds. So in this legal advisory, we answered this question by calling attention to the preamble to the exemption, which it clarifies that you can actually choose to divide your investments among various funds or investment vehicles set out by the plan trustee, similar to how we can go into our TSP plans and select certain funds that we want to invest in.
I think this is an important point, Rachel, because this is an area that I've often struggled with. This idea that maybe if we go in and select a specific fund that the exemption isn't available, and what we're saying is the preamble sort of allays that concern.
That's right, Patrick, and I think just reading the text of it, it was unclear. And so we're really clarifying here what we said in the preamble, that you can go in and select those specific funds.
Excellent. I think that's extremely helpful.
Okay, though keep in mind, though, that you still need to meet the other criteria of the exemption, particularly that the fund be diversified. So here's an example of how all this might work. Let's say you're an employee who still participates in an employee benefit plan, and you're selecting the Retirement Target 2040 fund. This fund, which is private to the company, looks a lot like a mutual fund, but it is not a mutual fund under our definition. This fund is also diversified. So if the employee is going to work on matters that affect her holdings in that fund, then she could rely on the employee benefit plan exemption to continue working on that matter. However, if she also selected a non-diversified company stock fund, for example, she couldn't use the exemption as to that fund.
And Rachel, in the case of that 2040 fund, that might not meet the definition of mutual fund because it's maybe not registered? Is that kind of the concern?
That's correct, yeah. If it's private to the company, it might not meet the criteria of that definition.
Excellent.
So if there's going to be a conflict with that non-diversified stock fund, she couldn't use the exemption as to that fund. It would have to either roll out of the asset into a qualifying diversified fund or into another category, qualifying category, to use our exemption. Now, the second part of the legal advisory focuses on the exemption's application to foreign employee benefit plans. And it clarifies that this exemption can be used if an employee is participating in a foreign employee benefit plan, as long as, of course, it meets all of the exemption's criteria. Now, the reason this one is tricky on its face is because the definition of employee benefit plan cites to the Employee Retirement Income Security Act, or ERISA, right there, and ERISA itself doesn't cover foreign plans, so the question was a little tricky just looking at the regulation there. However, in the preamble again, we point out that OGE has confirmed, as long as you meet the broad definition of employee benefit plan in ERISA, then the plan can qualify. So the fact that the foreign plan, is not covered by ERISA does not matter here, meaning foreign plans may qualify for our exemption, which I think will be really useful since, again, the underlying funds often don't qualify for that mutual fund exemption if they're organized or created under the laws of a foreign country. Now, one last thing I want to point out, though, is that these plans are much more likely to concentrate in investments in that home country. So that determination that the plans are diversified is particularly important for these foreign funds. So I'm going to turn it back to Patrick here, and he's going to introduce our next legal advisories.
Excellent. Thanks, Rachel. I think these are two areas where there's been a lot of confusion over the years, and these qualify and clarify some points that I've at least been asked many times. So hopefully, folks find this guidance to be very useful.
Yes.
So, thanks very much. So now Chris is going to discuss with us two legal advisories: Legal Advisory 1502 and Legal Advisory 1505, which consider specific questions OGE has recently received regarding how the GIFTS rules apply to certain kinds of events. So without further ado, Chris, it's all yours.
Great, thanks, Patrick. So as Patrick said, I'm going to talk about two legal advisories, LA 1502 and LA 1505. And both of these legal advisories focus on gifts of free attendance to events under Subpart B of the Standards of Conduct. Now, both of these respond to frequently asked questions that we have received over the course of a number of years, and which we've often we've provided oral advice on, but haven't put down in writing specifically how we address these questions. So we took the opportunity to do that this year. Now, both deal with specific regulatory definitions and how they apply to certain situations where there's an event. LA 1502 discusses when a meal or reception is not part of a gift of free attendance under 2635 204G, which is a definition of free attendance as used in 2635 204, which discusses when an employee may accept a gift of free attendance to a widely attended gathering or to a speaking event where he or she is assigned to speak. LA 1505 discusses how to calculate the value of an event if there's no admissions fee or ticket provided or required for any person to attend. So let's start with the first, LA 1502. And the question that we're dealing with or struggling with in this legal advisory is, does a gift of free attendance at an event under 204G include the waiver of a fee to a separate meal or reception? I'm not going to hold you guys back. Let's get to the answer, no. And let's talk about how we get there. The definition of free attendance under 2635 204G4 specifically includes certain items and intangibles and specifically excludes some items and intangibles. For example, food and entertainment that are provided to attendees and that are integral to the event and that are provided to all attendees are part of that single gift of free attendance under 204G4. The inverse of that, those are meals that are not provided to all attendees and that are not part of integral to the event, and entertainment that's collateral to the event are not part of that single gift of free attendance and are excluded from the definition. So let's look at two scenarios to see how this actually works. In the first scenario that I've put up here underneath the bullet 1, the conference fee that's charged to attend the event includes attendance at the substantive sessions, the morning session and the afternoon session, but it also includes a lunch that's provided to all attendees, and it includes an award ceremony that follows the last session of the day. This is the type of scenario that we see quite often with annual meetings of, for example, professional associations, where there are a number of different substantive meetings, and then there's lunch or coffee that's provided to all attendees, and it's followed by an award ceremony where all the attendees can go. And that's all included in the single gift of free attendance because it's all included in the conference fee. In the second scenario, you'll notice that I've put the lunch, which is a $15 lunch, in red, and this after party in red as well. That's because those are not included in the conference fee. As you'll note, the lunch is $15 in addition to the cost of the conference fee, which means that there's a separate charge to enter into to go to that lunch. And what it means is that only those persons who are paying to enter or to go to that lunch are actually allowed to go to that lunch. It's not something that's provided to all attendees, and it's not something that's integral to the event. And therefore, underneath the definition at 204G, it's not part of that single gift of free attendance. Now notice the party doesn't have a fee attached to it. I included this because the party is not part of the conference fee. It's occurring after the final session of the day, and it doesn't have a fee in the sense of there's no charge to attend. But I included it to remind everybody that the charge of a separate fee is sufficient, but it's not necessary evidence that a meal or reception is collateral to the original event. At this point, I'd like to move on to LA 1505, which also talks about events, but it focuses on a wholly separate issue. And that is, how do you value an event if nobody is charged to attend? There's no conference fee, there's no tickets. So here again is the question. And the answer that we've provided in LA 1505 is that you aggregate the market value of food, beverages, entertainment, and other tangible events that are offered to all attendees. Now, I'll note that if you are following the slides at home, there are some slight changes between the deck that we're working off today and those that may have been provided prior, so you may not see this slide in your deck. Now, I'll discuss this answer in a second, but I want to talk about why the question of market value to an event even matters. Now, there are a lot of regulatory reasons why market value matters and is important, because it goes into whether somebody can accept certain gifts or whether they can pay to attend an event if they could not otherwise accept free attendance underneath an exception in subpart B. But it's also important to consider the market value of events, even if it is permitted to be accepted underneath a exception in 204, because it plays into whether it would be prudent to have somebody attend that event. It may play into whether the agency has an interest in sending the person to the event. So it's important to consider even if it isn't a regulatory threshold question. So I want to point out 4 places where market value is specifically referenced and does come into play in determining the market value of an event. The first is market value is important if the employee wants to pay or is required to pay his or her own way through the event. Now, this is a particularly important consideration for our political appointees who are required under 13490 to sign the ethics pledge, because they are further restricted from taking gifts from lobbyists and registered lobbying organizations under Section 1, Paragraph 1 of the pledge, and they can't rely on certain exceptions that other employees can. So there may be situations where they'd like to attend an event, and the only way they can do so is to pay their way. Market value is also important if the cost of the event would total less than $20 or $20 or less. An employee can accept that underneath 204A, which is the de minimis exception. Now remember, it's important to determine the market value, see if it's $20 or less for that specific occasion, but there's also an annual cap on the de minimis exception. So it's important to determine that the market value from that source, including the event, is less than $50 per a calendar year. Next, with a employee is attending a widely attended gathering and the gift of free attendance is being provided by a non-sponsor, the market value of that widely attended gathering has to be $375 or less. That is a threshold question. If it is more than $375, the employee cannot attend, even if the other criteria of the widely attended gatherings exception are met. And finally, if an employee cannot accept or goes to an event and it is later determined that he or she could not have accepted attendance, a gift of free attendance underneath an exception, he or she is required by the rules to pay back the market value to the source of that gift. So the question of what is the market value of an event is particularly important for understanding whether somebody can accept a gift. If they can't, what they need to pay to ensure that they're in conformity with the rule. So what is market value? Let's look at the subpart Y definition at 2635203C, and this will help us understand how we got to the answer in LA 1505 that you are to aggregate the market value of food, beverages, and other personal benefits provided to attendees. Now, the general rule is that market value is the retail cost that an employee would incur to purchase the gift. If you look to the third sentence of the definition, which I've broken out into a third paragraph to emphasize it, you'll note that the market value of a gift of a ticket entitling a holder to food, refreshments, and entertainment is generally the face value of the ticket. So that's important to consider because that is the default. Now, in all occasions where retail costs can't be determined, there's a catch-all provision, and that's located in the middle of the slide, which is an employee who can't discern the market value of a gift can estimate its market value by reference to the retail cost of similar items of like quality. So if you have a ticket, use the face value. That's what the regulation says. If there's an entrance fee, use the cost charge to enter. And the gift of the entrance fee or the ticket is whatever a ticket holder is entitled to. What if there's no face value, however? Well, if there's no face value for a ticket, then you have to rely on the catch-all provision. You have to look to see what cost of admission would be, and you determine that in reference to the retail cost of similar items of like quality. We've, for example, looked at this particularly in 2007 when we were asked to determine what would be the market value of attendance at a skybox or a private suite. And after considering it, the answer we gave is you have to look at the most expensive publicly available ticket and then add other gifts that are part of that gift of admission that are given in connection with attendance at that skybox. For example, food or parking and other tangible events that are given to those individuals and attendees who are sitting in the skybox. Now that's good if you have a ticket or a publicly available ticket that you can base your determination off. LA 1505 considers a situation where there is no charge to anybody. There is no ticket that you can look at as a reference point to determine what would be the market value of an event. Now, the case where there isn't a market value that's readily ascertainable is still the same. You go to the catch-all provision in the definition of market value, and you look in reference to the retail cost of similar items of like quality to determine what the cost of that overall cost of the market value of the event would be. As we've said, and as we noted on the earlier slide, the way you do this is you look at the personal benefits that are provided to attendees. That would be the market value of the food, the beverages, entertainment, and other tangible benefits that are offered to employees. You aggregate the market value of those benefits, and that's how you get the overall market value for the event.
So I understand, Chris, we treat this very much like we do the Skybox example, except for in this case there's no face value of the most expensive ticket, so we simply aggregate all of the benefits this person receives that are attendant to the event.
That's exactly right.
Okay, I think that makes sense to me now.
That's exactly right. Now, one question that we do receive occasionally is, do you have to add in the rent or maintenance fees for the event venue during the period of time that the event is being held at that venue? And the answer is no. And there's a good reason why. Oftentimes, when somebody is going to an event where other attendees are being ticketed, those other attendees are helping to pay off the overhead costs, including rent, lighting, and so forth. And when you don't have to pay that, you're getting a discount. You're getting an extra benefit of not having to pay the overhead, which other ticket holders are having to pay. In the situation where nobody is being charged to attend, nobody is paying those overhead costs. And so you're not receiving any discount that a ticket holder isn't otherwise receiving. So the answer simply is that you do not need to add those rental or venue maintenance fees in. Now, there may be a question about how do you determine the market value of the food and beverages and entertainment so that you can aggregate them. Well, we've also provided a little guidance on that. The way that you determine that is you look at the retail cost of those items and the cost that an employee would incur to obtain similar items at a comparable location or event. If you're at a soiree at a very nice hotel and there are premium cocktails, you would look to see what it would cost to purchase like cocktails at the same type of event. Now, we've also put into the legal advisory that a very practical consideration, which is oftentimes ethics officials call the sponsor or the host of the event and ask the sponsor or host, how much does it cost to put this on per person? That's an okay practice, and oftentimes that's the only way to get information about the event. So what we've established in the legal advisory is that is an okay practice, so long as that determination by the sponsor is a good faith estimate and isn't impractical or implausible. For example, if your employee had asked that he could go to this soiree, and there was a celebrity chef, there was craft beers, and the sponsor said it cost $10 to go to the event, you may want to look beyond that initial quote to determine whether that is really truly plausible or not. So thanks.
Excellent. Thanks very much, Chris. I think that those are questions that come up very frequently, and having some written clarity and emphasizing that today is really helpful. Now we're going to turn it over to Sikora Panza, who will discuss Legal Advisory 1504, which provides guidance on which types of prepaid gift cards are considered to be cash equivalents and are therefore categorically prohibited under the $20 de minimis gift exception. I think this is another one that's come up more than a few times here at OGE.
Thanks, Patrick. Like Patrick said, this legal advisory talks about gift cards under Subpart B's $20 de minimis gift exception. And we did write this advisory because we've received questions periodically from ethics officials as to whether an employee can accept a certain type of gift card. So this advisory is our attempt to clarify the different categories of gift cards and how they should be treated. So to start, as everyone knows, employees are prohibited from receiving gifts that are given because of their official positions or that are from prohibited sources unless we have an applicable exception. The exception that we're focusing on here is found in 204A, which allows employees to accept an unsolicited gift that has an aggregate market value of $20 or less per source per occasion. Now, in this exception, we specifically enumerate that it does not apply to gifts of cash. So I think the reason why we are receiving questions or have received questions about gift cards is that even though these cards are, by definition, not cash, they may have some certain cash-like qualities because they transfer a certain amount of purchasing power to those who have the card. So this advisory clarifies when that makes a gift card a cash-like equivalent. So the question that we answer in this advisory is whether these gift cards should be treated as cash equivalents. And the answer is not a coy answer, but it depends. And what it depends on is the type of gift card that we are dealing with. So just to introduce y'all to the framework that we started with and that we based this legal advisory on, we essentially decided that gift cards could be categorized into two separate categories. One is the general use prepaid card, and the other is the store gift card. And in trying to come up with our conceptual framework, we looked to various sources, and one resource that was helpful for us was some regulations in 12 C.F.R. Part 205 that were issued pursuant to the Electronic Funds Transfer Act. And that basically was helpful because it helped discuss different types of prepaid cards, store gift cards, and what their salient characteristics were. So as I said, we decided that there were two general types of categories of cards that we could distinguish between for purposes of the Subpart B de minimis exception. And basically what type of card it was is going to depend on whether it can be accepted under the de minimis exception. So the first category we have is the general use prepaid card. And we have the little mock-up on the screen of what this card might look like. The key feature of this type of card is that it can be redeemed at multiple unaffiliated merchants for goods and services. Now, visually you'll see this card looks very similar to a credit or a debit card because it has a payment network logo in the corner. And that's the payment network of your favorite credit card brand. These general use prepaid cards display the same sort of logo. As a result, the cards function similarly to a debit card. Essentially, merchants that accept the certain brand of credit or debit card generally would also accept these sorts of prepaid cards or these sorts of gift cards. Now, in light of all these characteristics, we explain in the legal advisory that a general use prepaid card is a cash equivalent. And the reason why is because they can be redeemed at multiple unaffiliated merchants and essentially can be used to purchase virtually any good or service. So a tremendous amount of purchasing power. As a result, we say these cards would not be acceptable under the $20 de minimis gift exception. The example that we give in the advisory is a $5 logo branded card that could be used anywhere where credit or debit cards of that brand are accepted couldn't be accepted even though it's well below the $20 value, simply because it gives the recipient that unlimited purchasing power. The other category is a store gift card, and we have another mock-up here just to try and show what these cards might look like. Now, a store gift card has a much more limited universe of potential use. So this type of card, it's redeemable at one merchant or an affiliated group of merchants. And that second qualifier is because sometimes you'll see gift cards that might be used, able to be used at a family of different restaurants or different establishments that have some sort of affiliation. We say in the advisory that a store gift card is not a cash equivalent. And the reason why is because their scope of use is fundamentally limited. You can only exchange or use those gift cards to purchase items that are offered by the issuing merchant or the issuing affiliated group of merchants. One thing that we do in the legal advisory is we specifically highlight it's therefore acceptable under the $20 de minimis exception. Now, we highlight two kind of subcategories of cards that fall within this category of store gift cards, and these are mall gift cards and gift cards to online retailers. The reason why we specifically highlighted these types of cards is because we have received specific questions from ethics officials, and I think that these might seem a little bit tricky because if you think about a mall or certain online marketplaces, you can purchase an incredible diversity of products. I can get Q-tips at a big screen television and a new leather jacket, perhaps at the same mall or at the same online retailer. So the question is, are these store gift cards that are acceptable under the $20 de minimis exception, or would they be so general that they would be general use prepaid cards? What we say in the advisory is that even though these cards, depending on what mall it's to or what online retailer, might allow the purchase of, a fair variety of goods, they are still fundamentally limited because the recipient can only use that card to purchase items from that mall or from that online retailer. And because of that limited scope of use, we say that these cards should be considered store gift cards that are not cash equivalents and therefore are acceptable under the $20 de minimis exception. So again, the key factor there is because they have a limited scope of use, and that's the key distinguishing factor.
So it's the universe of merchants at which you can use the card that's important, not the diversity of the products that you can get from the merchant that's important in this case.
That's correct. And because if you think about, you can have it to a single store, a big box store that can sell multiple items, we don't take that into consideration to figure if that's a store gift card or a general use card.
Right, but we don't get to decide to take that card and then go use it at some different store that maybe we prefer.
Exactly. I can't take, a card to an online retailer and go use it to buy a cup of coffee down the street. I don't have unlimited purchasing power, and that's really the crux of our analysis there.
Excellent. Well, I think that helps make the distinction.
So the last type of card that we talk about really isn't a separate type of card, but it's one that we highlight separately in the advisory because I think it has a it has a high potential for either misclassification or misidentification. And we call it the co-branded card. That's just the terminology that we came up with. The visual depiction here, as you can see, it looks in many respects like a store gift card. It's got the store logo all over it, but if you look in the corner, it has the logo of the payment network there as well. So what do we say about this type of gift card? Now, this type of gift card, even though visually it might at first glance appear to be a store gift card, because or if it has that payment logo network and can be used wherever a credit or debit card of that payment logo network is accepted, these are general use prepaid cards, and they're not acceptable under the $20 de minimis exception. Again, we highlight these separately not because they're a different category, but because they can be confusing. We, in our research, came across some cards, for example, of a big box retailer that if you just looked at the card at first glance, it would appear to be a general store gift card, no problem, can be accepted, except you just look in the corner and there's the little payment network logo, and you see it can actually be used anywhere where one can use credit or debit cards of that network. It's important to pay attention also for malls, because some mall cards You may buy them at the mall customer service desk and it's a mall gift card, but if you look and it has the payment logo network, you might be running into the general use prepaid card territory.
Yeah, and I think this is an area where there's been some innovation in the cards. I think we're accustomed to seeing cards branded with certain kinds of businesses like airlines or hotel chains, and we understand with those that they can be used anywhere. They just happen to be co-branded. But with the advent of these cards where retailers are co-branding the card, it has the potential to cause some confusion. So we want to make sure that we're being mindful about where the card can be used, not the name of the business written on the front of it.
Absolutely, absolutely, and that's really the key, where the card can be used. So just to wrap things up a little bit, we have this lovely depiction here of a red herring because we, in formulating this legal advisory, there are certain characteristics that might be different between these two types of gift cards. And we wanted to just make clear that while these are distinctions, for purposes of this exception, we don't consider them to be distinctions with a difference. And the first one is whether the gift card can be reloaded. And you'll see that in banking regulations and different financial regulations, that might be a distinction that distinguishes one type of card from another. For our purposes, whether the recipient of the card can then put his or her own money on it after the fact, that doesn't affect whether or not we consider that to be a store gift card or a general use prepaid card. Another factor that is not relevant to this analysis is whether the gift card can be exchanged for cash. And there's multiple reasons why that's not a factor that we explicitly hung our hat on. Not the least of which is various states may have consumer protection laws that govern gift cards and when they go below a certain level and can be exchanged for cash. And essentially, while these may be factual differences between cards or, what one may be able to do with the card, as we've reiterated before, the key factor that we've focused on is whether the card transfers virtually unlimited purchasing power to the holder of the card. That's when we say it's functionally similar to cash and should not be accepted under the de minimis exception. The last thing that I want to point out is something that's mentioned in a footnote on the first page of the legal advisory, but I just wanted to make sure we called it to everyone's attention. We wrote the legal advisory in the context of the $20 de minimis exception, but there are other provisions in both Subpart B and Subpart C that address cash. And we say that where gifts of cash are specifically prohibited or treated differently in our rules, that you can use the analysis we have in this advisory to determine whether a gift card should be treated as a cash equivalent. So I will turn it back over to Patrick now.
Excellent. Thank you very much, Kim, and thank you, Rachel and Chris. Hopefully this has helped to clarify and provide some guidance on 4 very common questions that we receive at OGE. If you've not read the advisories that we've referred to today, I'd encourage you to go back and do so. If you missed part of this broadcast or just want to watch it again, this presentation, like all presentations, is available for future watching on OGE's Institute for Ethics in Government YouTube channel, which you can find at youtube.com/OGE Institute. So thank you all for joining us, and thank you those of you who sat in and viewed the presentation today. We got a lot of information in just 40 minutes. We hope to see you back here on July 9th for the Fundamental Series, or if you can't make that, July 16th for the Advanced Practitioner Series. Until then, I'm Patrick Shepard.